Hello, my name is Scott Smith, and I'm the Executive Director of the Arkansas Public School Resource Center, and thank you for joining us for this school board training session. In this session, we will be training you on topics required by Arkansas law for school board members. As you can see, some of the topics we'll be covering tonight are school board governance, Arkansas school choice, Arkansas school safety, Arkansas school funding, and financial management for Arkansas public schools. The team that will be joining me in this presentation are Ken Rich, who's our Director of School Finance, Michael Helms, who's our Director of Legal Services, and Trip Walter, our Staff Attorney, as well as Jim Robb, Director of School Support Services. Before we get into that session, we are also going to be covering many aspects of the most recent regular legislative session. For example, tonight we're giving you key information here, and we hope you will treat this training session as a resource guide that will help guide you to specific legislative acts and components of the LEARNS Act to go through the session. This particular slide, for example, shows you at the far left column on top how many bills were filed in total, 1,660 bills during this last legislative session. Out of that 1,660, 184 of those bills, or 11%, specifically dealt with K-12 education in Arkansas. And finally, the number of bills that became actual acts or laws in Arkansas went from 1,660 down to 890, and out of that 890, 127 became education laws in Arkansas, or 14% of all laws passed during that last regular session dealt with Arkansas education. A couple of these slides are going to be able to show you how we've broken down the legislative acts by subject matter. So on this slide, for example, you can see if we're talking about curriculum, here are the bills or acts that deal with those particular areas. If we're talking about funding, or if we're talking about school districts, so forth and so on. So we hope, again, you'll be able to use this slide as a resource. You need to look up acts or find out particular information as it relates to acts. One of the other things you heard about this last legislative session was the Historical Educational Reform LEARNS Act, or Act 237. This act was the governor's initiative, which was a land-sweeping change of many aspects of Arkansas education, and we have broken that particular piece of legislation down by its various sections. As you know, it was a very long bill, so we've broken that particular bill down by its various sections under the acronym for which LEARNS stands for. So if it had to deal with literacy or empowerment or accountability, you can find the various sections of that bill as you look through this particular slide for more information. All right, as we get into board governance, one of the first topics we're going to cover tonight is the Arkansas FOIA Act. Arkansas FOIA Act stands for the Arkansas Freedom of Information Act. This is an act that's been in place for a long time, since 1967. It's an act that specifically is focused with the public's right to know, or public's right to access. As it relates to public schools, we've tried to make this presentation very simple and direct, and it provides kind of a three-step test for determining when FOIA applies to either public meetings or public records. The second part of the presentation is going to be focused on when you are making a FOIA request, how properly to make a FOIA request, or when you have to respond to a FOIA request. As you know, as public school leaders, FOIA requests are often a topic that you have to deal with and work through the business of public education in Arkansas. Many times we're asked as to what the purpose of the FOIA Act is. Here it specifically states that, coming out of the FOIA Act and citing that particular provision of the code for which it applies. I'm also often asked about how do we know if FOIA really applies to school board meetings. So we went ahead and went into the specific FOIA provision, pulled out that section of FOIA that talks about your board meetings. In this section, we're only focused on meetings. We'll move to records in a little bit. So as you can see, the law is very specific as it relates to school board meetings and basically every type of meeting you might have, formal, informal, special, or regular. The shall requirement that all public school board meetings are covered under FOIA is essential in Arkansas. All right, here's our three-step approach. The first question we're always going to ask when we're dealing with a FOIA request as it relates to the meeting is the entity covered? We've talked about that just a slide or two earlier, how that we know that public school boards are covered. So we already have an answer to question one. Question two is, if so, is the meeting covered? That even though you can be in a public meeting, there may be some aspects of that public meeting that are private or not required to be in public. And then the final question three is, If the entity is covered and if the meeting is covered, are there any exceptions? And we'll dig into that deeper as well. How do we know whether a meeting should be in public or not? Talking about a meeting of your school board again, it's an event or gathering in which there are actually two or more members of the governing body meeting. How meeting? Two or more. It's hard to have a meeting with one person or less, unless you look at the bottom there and they said, hey, by the way, if you try to have a constructive meeting, that's where you try to have a meeting without having a meeting. Maybe an example of a superintendent calling board members and polling them on a vote to kind of have a meeting over the phone or by email or by text or something like that. Even though you didn't formally meeting, there's some case law out there where the courts have said, hey, that's a constructive meeting of the board, and we're going to consider that to be in violation of the public meeting requirement. But if you've got a public meeting requirement, how do you make it public? Well, here are the steps. The first thing you have to do is provide notice, which constitutes a date, time, and location of the meeting. How do you go about that? It has to be regular. If it's a regularly scheduled, you got to put it at least 10 days out before the meeting on your web page. The meeting has been rescheduled. It's got to be at least 24 hours before that meeting on your web page. And if it's a special or an emergency meeting, then you got to give at least 2 hours notice to the media outlets in the county. Why not on the web page? Well, obviously that's not very much time. People may not be looking at your web page or anything like that. So you have an obligation to provide that notice directly to them in that particular situation. Next, location. Location of the meeting must be readily accessible to the public. You can't do it in a way that thwarts the public's ability to attend. I like that word thwarts, and let me tell you where it comes from. We had a board that was actually pretty good at having meetings, and they were pretty good at having full attendance. Problem was that they were having their board meetings at a casino across the river over in Mississippi. And so somebody found out about that. The Attorney General got involved, and they decided that, hey, even though you're giving notice of the meetings and you're telling people where you're going to meet, the fact that you're not having your meeting at a location that the patrons of your school district can readily attend or have ready access to, you're actually violating the public meeting requirements. So be aware of that. Is that saying that you have to have all meetings on the school campus location? It's not. It's just saying that if you're having them someplace where it's really interfering with the public's ability to attend, either in person or virtually, then that could violate the public meeting requirements. Attendance. A lot of times we get people confused and they ask us, I thought we had to have a quorum before we had a public meeting. A quorum really doesn't have anything to do with whether the meeting's public or not. If you'll remember, I said 2 or more board members are all that's required to kind of cross the threshold for a public meeting required. The quorum is about whether or not you have enough board members for a necessary action or vote out there. And then the other thing you have to do to have a public meeting is you have to record the meeting at least by way of audio. You can also do it by video if you want, but under the law it at least has to be done by audio, and you have to keep that up to 1 year in your records after that meeting. Are there exemptions to the public meeting requirements? There certainly are, and sometimes it gets a little confusing. For example, school board members who are going to school board training, you may have 2 or more board members together, but that is not considered a public meeting of the board for purposes of FOIA. That's a training exemption of the public meeting requirement. So that's one type of exemption out there. What I'm going to point out to you here on this slide is you can still be in a public meeting requirement, but you may be called into a closed hearing in that public meeting. So don't get confused. You still have a public meeting going on, but within that meeting there are closed hearing options out there. Personnel hearings, for example, if they request a closed hearing option, the same is true for a student disciplinary hearing. They have the ability to ask for a closed hearing also in that public meeting. Another issue may be if you go into executive session. And executive sessions are limited to personnel issues, as you see on this screen, for the purpose solely of considering employment, appointment, promotion, demotion, discipline, or resignation of a specific employee. Now, obviously, you know if you go into executive session, you can't take action, you can't take a vote in that executive session, and for anything you decide to be formal or valid action going forward, you got to come back out into public and you have to take a vote in public on what happened there. All right, here's something that I think is really a big issue. We had some involvement in this. I think it's some progress. In my prior life, I was the chief counsel for the State Board and the Department of Ed, very familiar with having to do with FOIA requests on a large-scale basis, often by way of harassment. The one thing that public entities did not have back then, and still don't have to a large degree, was kind of attorney-client privilege. And as a result, oftentimes we were getting FOIA'd for things that we were in litigation over, or documents that we had that were related to settlement conversations and things of that nature. And that makes it very unfair. There was already a discovery process in litigation where both sides, under the court's supervision, had to provide information to each other. But in addition to that, parties were able to use FOIA as a weapon. You may have seen that most recently in the Cabot School District case and some other cases around the state out there. It's always been a disadvantage for the state. It's always been a disadvantage for their political subdivisions. So we're very excited about Act 883. It creates an opportunity for you to go into kind of an executive session, if you will, to discuss these issues. These issues are very broadly defined, so take advantage of that broad definition until there's more clarity on these points. But be aware of this. Here's the one thing I want to make you aware of and be concerned about. You can't quite do it yet. This bill doesn't go into effect until May 1 of 2024. So it's not out there lawful laws of the state of Arkansas at this point in time, but be aware of this. You know, the other thing with regards to the old executive session on personnel issues, the only party entitled to be there is the board, but they could invite a supervisor, including the superintendent, if they was directly responsible to the supervision of the employee or the personnel issue they were involved in. You couldn't have your attorney in there. With this particular bill, though, you can invite both the superintendent and the attorney for the district in there, okay? So this creates a little bit of an attorney-client privilege, at least for some conversations out there. And, you know, it's a step in the right direction to kind of create a more level playing field as it relates to litigation or other legal matters you're dealing with. Be informed on this, be wise around it, and use it properly. Again, any questions on this issue, we'll be happy to help out. We're going to move into the records portion now, so we've kind of come out of the meetings portion, going to move over into records. What is a record? I usually start this section by telling everybody that FOIA is, first of all, only concerned about records, not information. And why do I make that distinction? Well, let me say it this way. A record always contains information, but information does not always constitute a record under FOIA. So it's important that we kind of understand what is the definition of a record then. A record under FOIA is a writing, recording, or other electronic information. It's defined as a public record only if it's both kept in the possession of the school and constitutes of the record of the performance or lack of performance of an official function. And let's go back up to this kept concept. Some people might say, well, hey, if the record is not on the school campus, or if it's not in the possession of the custodian at the school, then it doesn't meet the definition of kept. Well, unfortunately, that's not true under Arkansas law. So let's say the district has some attorneys under contract with them, or some engineers, or some other kind of vendor, or some educational group that they're working with. Even though those records may be in the possession of a third party, if that third party is working at the request or the behest of the school district, those records are likely to be considered records kept by the school district and subject to FOIA. Again, you see that in a case that's going on with an Arkansas school district right now, where people are requesting records with the attorneys for those school districts, even though those two attorneys in that firm were talking to each other, and the school district wasn't even involved in that. So just keep in mind that this definition of what is a record as it relates to being kept is very broad. Now, on the part of performance or lack of performance, that's very broad as well. And this is usually where I tell folks about a Pulaski County case a couple of years ago where there was an employee of Pulaski County. Pulaski County had let out some contracts and was doing business with a vendor. There was an employee for the vendor, an employee for the county, and they really decided that they liked each other. And I mean, they decided they liked each other a whole lot. They were sending texts and emails. They were sending pictures back and forth and love notes and all kinds of interesting conversations out there that really didn't have anything to do with his performance. So the county argued when the Democrat Gazette requested those records under the FOIA Act. The county said, look, this was an individual who was kind of doing whatever he wanted to do while he was working for us. We didn't know about it, therefore it didn't have anything to do with his performance. The court looked at that and said, I don't think that's the way we look at it. I think the way we look at it is that record shows that he was either doing his performance or he was not doing his performance as a public employee while he was doing whatever he was doing on those text or emails out there. So I tell you that just to make sure you understand how broad that definition is there, and how that there's really not any record that's probably not going to meet that definition. So keep in mind, as it relates to emails, text, kinds of records out there, communications by your employees, there's probably not a right of privacy expectation to those records. So just be aware of that and keep it in mind. Additionally, with regards to the records, it's presumed to meet the definition of a public record if it is held either by the entity covered by FOIA, which is the public school, or by a public employee within scope. So we talked about that a little bit earlier, and we'll move on from this slide. Kinds of exemptions. So there's really two sources to exemptions out there. It either is an exemption that's created by law, by statute, or constitutionally. So if we were doing this board training in person, in addition to that PSRC legislative handbook, we usually give you the latest copy of the FOIA handbook, which has the FOIA law in it. It also has all of the exemptions to FOIAs. And we give you a couple of examples here. Keep in mind that FOIA is state law. FERPA, down at the bottom, is federal law, which stands for the Federal Educational Rights Privacy Act. The irony about that particular act is it's actually a disclosure statute telling parents when they have a right to look at their students' records. And it used to be, back when I was counsel for the state again, the FOIA law said, hey, some of those records could not be disclosed, or they could be disclosed, and that might be in conflict with FERPA. We had a problem there. Why is that a problem? Well, to violate FOIA could be a criminal or civil penalty. To violate FERPA just really exposes jeopardy to your federal funding in some ways out there. So we had to go back into legislative session and get that cleaned up. And what we came out and said was, hey, anytime FERPA says a record is subject to the public right to know, FOIA now says the same thing. Or anytime FERPA says it's not subject to public disclosure, FOIA is in agreement with that as well. Why do we rely on FERPA that much? FERPA did a really great job of thinking about when records should be disclosed and when they should not be. Took into consideration law enforcement, medical personnel, DHS, all of the various entities and groups out there that would want to look at student records. And so it's a good source, and state law just coincides with it. The other ability to maybe be exempt from FOIA is a constitutional provision with regards to an invasion of privacy. Now, even though that's out there, that's a really high standard or bar to get over. Referring back to that Pulaski County case I told you about just a few minutes ago, there was a lot of information that was extremely private, particularly the photographs and things of that nature that was going on between those two employees. And when the county lost their argument that this really wasn't a county record, it was an individual person's record, they also tried to argue that, hey, you shouldn't release these records because it was going to be an invasion of their privacy. And the court said, I don't think so. We got a public entity, a public employee, public resources with regards to the public contract out there, and we're going to determine that the public has a right to know. So what they were pointing out there is that, hey, even though those were extremely private conversation, extremely private pictures and things of that nature, this standard is very hard to get over because the public has a right to know. The way the court gets around it is they'll make the record public, but they may redact some of the information in that record. So in that case, they went ahead and made the emails, the text, the correspondence back and forth public, but they did redact some of the pictures. Not all of the pictures were made public out there. So keep in mind that the constitutional exemption exists, but it's a very high exemption to get over. A couple of other exemptions out there that have grown in interest over the years is this safety exemption. You may ask why we have to have a safety exemption now. Well, obviously we're very concerned about active shooter issues, pedophiles, other types of concerns or problems that schools unfortunately have to deal with today. The legislature created a very broad exemption under safety. And so I encourage school folks to be aware of that and think about that if they need to use that exemption at times. And again, we're available to try and help on some of those points. And then you've got other specific laws like Social Security acts and other acts out there that specifically exempt things, and FOIA has recognized those exemptions as well. All right, We're going to talk about some things that you often get FOIA'd on, and that consists of personnel files or evaluation records. First of all, what is the definition of a personnel file? It's a record about a public employee or an official, and it's not an evaluation. Okay, so that's kind of a roundabout definition there. The test with regards to personnel records, you kind of might think otherwise, is that, hey, unless it's a clearly unwarranted invasion of personal privacy, and I just told you that was really hard to pass, you've got to disclose it. So just because someone asks for a personnel record, the record is probably subject to disclosure. Now keep in mind again, even though the record may be subject to public disclosure, there may be very many pieces of information in that record, like social security numbers, home addresses, things like that, that are not subject to disclosure. So I hope you get this idea that I was alluding to earlier, that there's a difference between records and information. The record or the document may be subject to public disclosure, but there may be information within that record that is not subject to disclosure. And that brings me to a quick point I want to make. If you don't have the record, you don't have to create the record, usually. There's one exception with regards to large data files out there. So often we see schools get a FOIA request where they're asking questions about information, but there's no record at the school on that information. So it usually pops up around millage elections or school board elections, and maybe there's some opposition to those issues, and someone sent a very interesting question to the district on that point, but there's no record on that. You're not obligated under FOIA to answer questions about information. You're only obligated under FOIA to provide access to records to the public that are covered under FOIA out there. All right? So let's move to the evaluation piece of this. So the evaluation is kind of the flip side of the coin as it relates to the personnel record. So the definition of evaluation is it's a record created by the employer, and obviously it's an evaluation of the employee. But the rule here is you withhold disclosure of an evaluation record unless the four elements to the right there, to my right, are in place. The person was suspended or fired. The discipline is final. That means that there's not another administrative step or an appeals process or anything like that with this individual. And the record was relevant. Now, let me be clear. That does not mean that the record had to be the sole reason that the person was suspended or fired, but it was involved in the process. It was looked at, considered, or part of the packet out there. And there's a compelling public interest. How do we usually know there's a compelling public interest? Well, obviously somebody's made a request for that evaluation record, and that's usually enough out there. So if those four elements are in place, then you disclose that evaluation. If they're not, if any one of those is missing, then you withhold it, okay, which is the opposite rule with regards to personnel records. All right, kind of a quick list of some commonly exempted items maybe in a personnel record. You heard me mention it earlier: social security numbers, medical information, tax information, retirement information, date of birth, things of that nature. So keep that in mind. Even though the record may be subject to disclosure, that information is not subject to disclosure. What about items that are not, or should be included in those records? Name, salary, contract, employment application, resumes, educational backgrounds, things like that. We see a lot of record requests with regards to salary information, with regards to educational backgrounds or resume qualifications for positions out there, things of that nature. Of course, the list is innumerable and much larger than this, but this is just some common items that we see out there. Part two is how do you make a FOIA request and how do you respond to a FOIA request. It's pretty simple. Any mode, any method will do. We were headed to Fayetteville the other night to do a board training, and there was a record or a document at the Department of Education. I picked up the phone and called an attorney over at the department and said, hey, I'd like to look at this record. I'd like to see that record. I didn't send anything in writing. I didn't send an email. I didn't send a text. I didn't do anything like that. I didn't make a video or an audio. I just called someone and made the request. So that method is sufficient. I do have to provide, or the requester does have to provide enough specificity so that someone can locate the records with reasonable effort. So oftentimes people say, hey, they just want to see a record as it relates to a really broad or general topic out there, and you may have 1,000 records or many records out there, that could fall under that definition, and you may be able to claim the specificity issue as a reason to deny that request. And you heard me say earlier that you do not have to create a record usually, so the record must exist or is readily available in a format out there. So don't go creating records if you don't have to, because you're not required to by FOIA to create a record out there. The only other thing I would say on this slide, and I think it pops up a little later, is under the Arkansas FOIA request, it has to be made by an Arkansas citizen. So a lot of times you see FOIA requests that come flying in from out-of-state vendors or out-of-state parties. They haven't bothered to check up and have an Arkansas citizen make the request for them, and in failing to do so, they just gave you the ability to deny that FOIA request. It's not a hard issue to get over. They usually the next day call a law firm or call somebody they know in Arkansas and see if they can submit the request through them, and if they do, then that checks the issue. I would also point out, don't get confused. You do have some federal records because of the federal funding that schools get, and the federal law is not subject to the same laws as the state law, so just keep in mind whether it's a federal record or not, and whether it falls under the federal FOIA request or the state FOIA request. All right, this is a good slide. It's 5 questions on FOIAs, the who, what, when, where, and how you go about it. We've covered a lot of that up front already on the who and the what. How, you get the record request to the custodian, they evaluate whether or not the personnel file or an evaluation record or what covered by FERPA or something like that. You then determine if copies of the records are to be provided. People ask, how quickly must I respond to a FOIA request? Well, all things being considered, if the record is subject to disclosure, then unless the record is in active use or storage and you claim that, you have to make it available immediately. All right, so you do not always have to provide copies. Sometimes you just have to make access available. So you tell them that they can come to room 245 of the administrative office of the school between 2 and 3 o'clock on Tuesday or Wednesday or whenever, and they can come over and look at the record. They're probably going to turn around and ask for copies. You can make copies, and if you do, you can charge for some cost. You can only charge for actual cost of the copy, except you cannot charge for your personnel time involved in that. And if the cost exceeds $25, you can require that they pay up front before you provide the records to them, but you do have to provide an itemized bill of all the cost if you are going to charge them for anything. So on the active use or storage, a quick example, again, when I was at the state, we're getting ready for a hearing on a Monday, and on a Friday afternoon, I had an attorney on the opposing side send a FOIA request over for all of my trial records. They wanted to look at my notes that I was going to use in the Monday hearing. And again, we didn't have this attorney-client privilege, and so they were actually records that they were entitled to ask for. That was really frustrating because we'd already been through the discovery process, all of that had shut down, and they just sent this FOIA request at the last moment to see whatever we were planning on doing at that hearing. So I had to decide whether I was going to make the records available or not. We go rolling into the hearing on Monday. The judge wants to know, because they brought up this as a pretrial issue, that we haven't provided our records. They asked if we were going to provide them. I said we were not. He wanted to know how and why, and I said because the records were in active use for the hearing that we were there for that day, and that after the hearing was over and after we didn't need them in active use, I would make them available. Obviously, they weren't going to be relevant to them after the hearing was over with. So you have to think through these things in some ways and how you might avoid them. So I always encourage you, if you've got a FOIA request, talk to your legal counsel or someone who can help walk you through some of these issues out there. We've talked about the personnel requirements. One thing I would point out is if you get a personnel request, you've got to provide notice or notify your employee that's had their personnel records requested. You've got to do it within 24 hours. The requester, custodian, other subject may request an opinion from the AG about whether or not something in that personnel record is subject to disclosure. Again, if you do that, it suspends the timeline. Sometimes you have to ask whether something's a personnel record or an evaluation record. And again, even if the personnel record, which has the general rule of disclosure, is subject to public information or disclosure, there may be information that you have to redact in that record. The best way to redact that is to take a black magic marker, completely scratch out that information, and then make a copy of it so they can't read through when they hold it up to a light or something like that. These are some recent changes. I'm going to let you read through those at your leisure. Also, under changes this last session, if you don't have the records, you have to respond and let them know you don't have that record. You can't just leave it hanging out there as to giving a response back to them out there. So be aware of that. So we're going to move to the school board training requirements now.